thanks so much for this time together. Rohan's going to kick it off, and then I'll talk afterwards. And hopefully we'll have a lot of time for just brainstorming together and thinking together. Do you want to take the floor?
Yeah.
Okay.
Sorry. Just make sure. Okay, cool. No, I'm going to sit down. Oh, actually, some people can't see me. Okay, I'll stand up. Fine. Oh, shit. Sorry. It's nice to see you all. This is the first time I've been at Levy after 10 years of being involved in MMT, so it's lovely to finally be here at such a beautiful place. It's fine? Okay, cool. I got into this community as an undergrad in Sydney, in Australia, studying political economy. I didn't know at the time it was a heterodox program, what that actually really meant. But I always knew I was going to go to law school. And I did that during the global financial crisis and started reading a lot of blogs, very bored student overseas in America. And I went over on exchange, and I started coming across these debates about macroeconomics, trying to understand what the hell just happened. And I had a background in debating, and that's always a good prerequisite for going to law school. And I just followed these debates and decided, as I kept watching them, that some groups kept winning and others didn't. And as I was trying to understand this stuff, I had friends who was at the Wharton Business School and going on to Wall Street and sort of had the perfect training to understand finance. And I would have these arguments with them because we differed politically. And over time, they just ran out of criticisms, ran out of reputations. And I went, my God, what these guys are saying on the blogs doesn't just sound right to me, a layperson idiot, but actually maybe be actually seriously correct, and the experts don't have a response to it. And this kind of mattered to me because I came to law school to do something important. I didn't know what it was. I didn't know what the right issue yet was, but I knew I wanted to try to make a difference that was at the international scale, and I knew I wanted to be a lawyer. At that moment, the MMT kind of paradigm seemed to me a very, very important legal argument. There were a bunch of legal issues that if the lawyers understood this, they would actually be able to do a lot of good things. And I thought, well, surely they've got to be smart lawyers. There's the law of family law, there's contract law, there's tort law, there's consumer law, there's energy law, there's international maritime law, there's the law of space. Surely there's the law of money. I can't wait to go to law school and find the legal equivalents of all of these economists. And when I got there, it was pretty bleak, actually. Christine Dezan and a few others were out there in the wilderness, but there really wasn't a field. And it was kind of scary to find out that the lawyers were actually all just repeating the same economic concepts they'd studied in Econ 101 that everybody else was criticizing. And that was where they started from. And it made a big difference because, at least for me, you go to law school not simply to learn about the law, but to make justice, to actually take power and win and do something. And MMT, what I thought was so amazing was they were winning not only on the substance, but they got the politics right, they got the strategy right, they were speaking to the right kind of people, they were trying to build a politics that included the kind of people I cared about. And it was important to me because it's not just enough to learn how the system works. It's not just enough to learn how to be descriptive. You have to actually do something with it that matters. And there's a big difference between learning how to be an effective lawyer and learning how to make justice. And what I realized is that there's a big difference between lawyers who care about money because they want to be effective lawyers and lawyers who care about money because they want to make justice. When I was a child, my father, who was a litigator, would come home and I'd be 4 or 5 years old and I'd say, you know, good judge or bad judge today? Because as every good legal realist knows, that's probably the most important question, not the facts in front of you or whether or not you think you've got a good argument on the law. When judges interpret the facts, when they make factual findings, when they interpret the words in the statutes that other people read, they're not just playing balls and strikes, they're making the law. Right? The politicians and legislatures make a different kind of law, but they also make law. And in a country like the United States, it's broader than that. They claim an adherence to a politics based on the rule of law, whatever the hell that means. What it means is that we aren't simply able to say might makes right. You have to justify it in reference to a legal argument. Does that mean that power doesn't exist? Of course not. Of course it exists. Does that mean that those justifications aren't pretextual? Of course not. They're often pretextual. But it means you have to justify it that way. You have to write up the analysis and people can attack that analysis. And in a country where we are theoretically committed to the rule of law, the people in power, the people who can claim legal legitimacy, are the ones who can make decisions. And what to me what you can get from that is that lawyers play a role very similar to economists, but maybe even closer to the thing, of secular priests. Thurman Arnold, one of my favorite legal realists, he was a lawyer, he was a small town mayor, and then a legislator, and then he founded a law firm, and then he was on the Second Circuit, and then he was FDR's antitrust division head. He was a real cowboy who wanted to have an adventure, and he went across all of the different institutions of power and government at a time when you could still kind of do that. It was small enough. And he used to say that, yes, words, legal concepts are substantively empty, but formally important. The word reasonable doesn't mean anything, but it means everything in the law, because even though it doesn't mean anything, whatever you can justify relevant to precedent, relevant to other judges, relevant to the state of legal scholarship, relevant to the facts on the ground, if you can make that word reasonable mean those things, then you can justify what you're doing, not as an exercise of pure political power, but an exercise of legality. And even if legality is a form of power, it's not the same as pure naked power. It's not the same as Queen Cersei in the Game of Thrones saying, might makes right, power is power, those guys are going to come and drag you away. And it's an important difference because the law is always backed by violence, it's always there in the shadows, it's always the thing that comes out when all the other things fail. But as an administrative practice, as an administrative problem, the law doesn't rely on force most of the time, it relies on spontaneous compliance. It relies on Gramsci's concept of cultural hegemony. The reason we don't cross the road, the reason that we pay our taxes, even though the taxman isn't going to necessarily catch us in an audit, is because that power of law goes a lot further than knowing whether or not a police officer is actually going to get you in the next minute. So that idea of owning the words, being able to make the argument that you want through the game of law, is, in my opinion, the way that most politics actually plays out. Not to say that the lawyers do everything, but they are an important priestly caste, and especially in a country like the United States that claims constitutionalism and the rule of law is central to its political identity, they are. And you can see this when generals choose to acknowledge or not acknowledge a coup. You can see this when the bailiff chooses to actually carry someone away in handcuffs because the judge says so. The power goes from the word to the gun, not necessarily the other way around, even if there is a dialectic. Right? In one sense, the bailiff could always just shoot the judge and put another judge in place, but 9 times out of 10 they don't, because the judge keeps them on side and can make that room theirs. And if you've ever been in a courtroom, you ask whether or not the bailiff or the judge is running the show, it should be pretty obvious. So when I'm talking about smart lawyering, when I'm thinking about what it means to go to law school to actually make justice, I'm not just talking about being a great advocate, having clients, doing well for them, being a good legislative assistant, writing some good bills, being a good regulator like our great colleague Bill Black, and putting some of those bad guys out of what they can otherwise do to hurt people. I'm talking about the idea of being a good lawyer so that you can understand legal power. People are here because they understand economic power. They understand the power of stories about who we are, where we come from, how we make stuff, how we distribute things, who should get what. But the legal story is also a story about what's fair. What's the limits? When do you get to say no? When do you say you can't do that? That's enough. That's not in your right to do things. That's my right to say no. And that is as powerful as when people say, well, that's just economics. Oh, that's just basic economics. We all know the power of saying that in this room, because that's why we're trying to fight something else. We're trying to show that that's just economics can be contestable. But one of the differences is that law is already contestable. Law schools have red team, blue team. There are obviously ideological conditions about whether you can get to law school. There are certainly class conditions about whether you can get to law school. But the idea that Harvard Law School is never going to let in a single radical leftist isn't simply true. And if you compare the number of PhDs out of the Harvard Economics Department that might be radical leftists versus the number that go from Harvard Law School, you'll see that we have a much bigger beachhead in one than the other. We have a much bigger ability to ideologically contest within the top elite halls of power in the law schools than we do in the economics departments. So it's not that, in my opinion, economics is subservient or inferior, but when we look at the landscape to actually making action right now, my line when I first came to MMT was, you might not ever take over Harvard Economics Department, but we can take over Harvard Law School and they'll beat Harvard Economics Department. Jason Furman, who was Obama's chief economic advisor, Council of Chief Economic Advisors, was at a conference on law and macroeconomics at Yale Law School a few years ago that I was at, and he said, when I was in the White House, the lawyers made all the really important economic decisions, and my job was to come in and make sure the math added up. Now, he was being a little bit polite, etc., but there was a there, which is, he's the chief economic advisor, but economic policy is being, in many parts, directed by the people who actually have to put it into practice on the other side, have to interpret the rules, interpret the provisions. And that idea of having different contested visions of lawyering, and that lawyering, in sense, is a sort of secular priesthood, means that there is a way that we can re-look at that Paul Samuelson quote about useful and useless priests. One of the most famous kind of MMT points that a lot of the orthodoxy says we can't challenge that balanced budget myth because to do so would pull back the veil and expose society to anarchy. And another word, of course, for anarchy there is democracy, is enlightenment, is education, is empowerment of people unlike him. And that's one of the things I think that is interesting about law, because law isn't owned by the state. Law isn't owned by the government. Martin Luther King says an unjust law is no law at all. A 5-year-old negotiating whether or not to go to bedtime is making pretty good legal arguments at the age of 5. And whether or not their parents, the state, agree, they know there's a difference between unjust and just rules coming down from upon high. So, in my opinion, what we need to start thinking about is not the kind of new atheist, Sam Harris, Christopher Hitchens, God is dead, don't you get it, you idiots, but a little bit maybe more of the difference between good and bad priests. Thurman Arnold, that guy I was talking about a second ago, he used to say, my belief is that mankind is born to be harnessed by priests, it's just the cross that we have to bear. But I can tell the difference between good and bad priests based on the outcomes they produce, based on humanitarian values. When I say priests here, I don't mean people designed to bamboozle and keep people ignorant. I mean a priesthood of enlightenment, a priesthood of science, a priesthood of humanitarianism, a priesthood that says actually the best way to make sure what's good in the world is to make sure everybody can read the damn Bible, not just the people who can speak Latin and wear robes. That every child gets to learn how to read and think for themselves about what's important, and that we pass the mic around in the church, so it's not just the old guy at the front who has the most power telling everybody what is. It's a church where we get to make music and talk about community and do all that stuff where everybody gets a voice. A little bit more Quakerish, a little bit less Catholic Church, perhaps. And that distinction, I think, is important, because whether we want to admit it or not, what MMT is doing is a form of its own priesthood. It's not simply dispelling other priests and leaving us with science. It is saying, don't trust them, trust us. We're better. We like you guys. We care about you. We're not bad priests. We're good priests. And the reason we can tell we're good priests is because you finished listening to us and you're empowered. We're not hiding information from you because we're afraid that you might make anarchy, because for us, anarchy is democracy. Anarchy is saying we don't have the right to tell you yes or no. We get the right to say, here's what we understand, and you get to make a decision. And that's obviously itself a bit of a fiction, because we're constructing choices. Parents say to kids, you want broccoli or carrots? There's a choice, but not really also. But in many respects, this is where people have to have the courage of their own convictions, have to have the courage of what they're trying to do with the power they're trying to build in the world. And we tell myths and stories in some situations to keep people ignorant, but in some situations to teach moral lessons to children. We tell fables that are reductive and simplistic, sometimes to bamboozle or obfuscate, and sometimes to enlighten. And when we are telling the stories we're telling, when we simplify things down to memes and we tell origin stories that maybe historians will pick at the edges but broadly agree with, what we're doing is trying to reset the narrative, trying to reset the myth. 95 theses stuck on the walls saying, actually, you get the right to commune directly with what you think of as justice. God's dead, but let's call it justice, right? And all of this, to me, is a way of saying if we actually want to make economic justice, we have to make sure that we kill the old priest, but also we don't think that there's not going to be a temple anymore. That this role that we're all constructing here is a heavy responsibility for leading society, not just doing some science or talking about some ideas. And that brings me to why law school is such an important battleground, in my opinion, from MMT. I came to MMT, this community, after being a long-time internet reader, long-time listener, first-time caller. Maybe some of you in the room will have that experience. I was in the middle of my second semester of law school, pretty disappointed and despairing with the state of the legal education and what ideological training I was being forced onto me. And my torts professor, who was a law and economics guy, was a dip. So I left my torts class and went downtown to a Minsky conference at the Ford Foundation. And I just invited myself and sat there in the back, quiet, just listening, lurking, and then found myself at a lunch table with Pavlina. I said, my God, I read you all the time, and I've been basically drafting a fantasy baseball league of seminars that I'd love to be learning at school instead of what I'm actually learning. Would you be interested if I tried to organize it? I'm the events chair for the Workers' Rights Student Coalition. She said, yeah, of course we'd love to come. So I put on 8 events, got all these student groups, made it look like a whole big deal. The administration didn't know, didn't care, they didn't have a right to stop me. But when I put those events up, it looked like it was a Columbia Law School event. Like, the kids call this stealing valor. And the idea was, well, suddenly MMT, that has been struggling to break out of heterodox small universities in the economics departments, is now at the Ivy League Law School at the center of New York, looking pretty legitimate and doing a damn good job. And that was the start of a expansion and infiltration of the legal academy that now, I would say, in the United States covers a pretty big swath of the people involved in anything related to money, finance, economics. The new generation of students, the new generation of regulators, we're building an army, and that army is not limited by the number of PhDs we can reproduce. A good PhD program maybe gets a handful out a year. We train 450 law students a year in one school alone. And if you get half of them, if you get 10% of them, that's 45 a year. And they don't all have to get one job in academia with its waning job market. They can go out and learn how to work for non-profits, for governments, etc., and still be lawyers, still have that edge to say, this is technical expertise, I can argue with anyone because the law is in my pocket, not up there with the state. So it's a subtle and important distinction, in my opinion, the difference between saying money is a creature of the law and money is a creature of the state. It's an important substantive distinction because even though we normally see law come to us from the state, there's law in small communities, there's law in people who put their chairs out on the lawn even when they're not supposed to. There's law in the people who carry the pocket constitutions and Martin Luther King marching and giving sermons that inspire people. And the difference in a world where we have large societies that are not face-to-face based, so we need institutions to mediate it, means that the law usually comes to us through the state. But it's not the same. And that's an important distinction. Just to give one minor metaphorical example, when I was a children's attorney in New York, I represented children as young as the age of 4 in direct services. That is to say, they tell us what they want. Even if I disagree, I do what they want. Why? Because I'm the attorney and they're my client. And that was set up through independent, non-profit law firms that look and run like a regular law firm, but get a contract from the state. That's different from the State Department of Children's Services. Why? Because the State Department of Children's Services has an obligation to look after the kids, but they do so also with the interests of the state. They do so also with the interests of the administration of children's services, interests of policy. What does this individual decision mean for every decision we have to make for the next round of kids? And that's an important perspective, but it's not the same perspective as saying I'm standing up for the individual legal interests of the child. Both of those are fighting with legal power. Both of those are fighting with legal power in the name of progress and individual empowerment. But one is the state and one isn't, in one sense. And that's an important distinction when we think about some of the issues now with fascism, with imperialism, with the dark side of collective action without democracy and the dark side of state power without civil liberties and a little bit of anarchism at the edges. And the concept of law, the mode of power that is law, can accommodate a little bit of anarchism at the edges. The concept of law can accommodate a challenge to the state apparatus on democratic grounds, even while legitimizing the idea there has to be some state apparatus. States state theory of money, calling it that, even if what they're really meaning is a legal theory of money, is an example of framing that for an economist might not look that different, but from a lawyer looks very, very different. And we're starting to see that play out in some of the optics and the politics more broadly. Even if the concept, even if the term is substantively empty, it has a political content that we have to deal with. We have to deal with the optics, the symbols, on their own terms. Just like the word reasonable, we have to accept that there is a politics of people who are very progressive, interested in justice, interested in the things that we want, but the word state means something different than justice, than law. My first conference at first talk at MMT conference was called "Is Money a Creature of the State or a Creature of Law?" And it was a friendly, gentle, not corrective, but provocation. The MMT should move that language. And if I knew Aberlour, if I'd known Knapp, I would have made the same suggestion to them too, that we can say money is a creature of law and that it primarily embodies through the state in modern societies, like modern in the Keynes sense, but that it is important to separate those two concepts out even as we make most of our politics centered around state action. Because people think of the state, they think out there. Even if we're all part of something that is the state, we as individuals experience that out there. We're all part of humanity, but when I think of humanity, it's all of you, not me. So when I think of the state, I think of something out there. But law is something that I can contest. Law isn't something necessarily out there. I can say I think that's bullshit, and that actually matters legally, especially if I'm sitting on a jury, but especially if I'm sitting on a judge, in a judge's seat, or especially if I'm arguing on behalf of somebody else with a legal license. So thinking about this both politically right now, some of the big political and optical challenges or critiques that MMT is grappling with, still grappling with, even as it's ascendant. Thinking about it substantively, is it actually more accurate to say it's always the state versus it's the law? And thinking about it in terms of sociopolitics, building the power of a movement. Law needs to be, in my opinion, taken a lot more seriously, not only by MMTs, but by economists. Because we take you guys very seriously. I know because I did the undergrad thing and it was those ideas that everybody is swimming in law school. But there is a dialectic. There is a back and forth there. And that sort of fine-grained, subtle, a little bit ironic mode of power that lawyers say, oh, I'm just acting on your interests. I'm counsel, you're the principal. It's true in one sense, but it's also ironic in another. So hopefully we can talk a little bit about where things are at now, the state of the legal organizing and things, but hopefully as you read that word state in the MMT literature, we can start to think of it as also meaning really law, and that has a much wider, expansive conception of power and action. Thanks.
So after I finish talking, do I? What do I do? Okay, sounds great. Cool. What did I do? Groovy. Super cool. Hi, everybody. Thank you. This is my first time here, and it's crazy, right? To be around people who are inspirations morally, intellectually, at least for me, that's been the case. And then just taking a walk over to, the lunches and dinners and getting to talk to people and sort of listen in on conversations. It's been really exciting. And I hope this space, I want to share some stuff with you that we could dig a lot deeper into, but really just to set the stage for us to have actually work together. So rather than sort of talk at you or just somehow pass on information, if you could help and we could get into a collaborative environment and do something, could really use your help. And what I want to talk to you about today is I came to this thing into academia as a public international lawyer, essentially. I mean, I say that, right, to certain people where I would need to say that, and probably that's how I would justify my check, right? Now I'd say law and technology. It used to be public international law. And what lawyers have sort of like increasingly has been amplified is the fact that law is a necessary, but it's not a sufficient explanation of this world of struggle and the sublimated suffering that we go through and the way we want to make it better and us understanding the geopolitical climate and et cetera, et cetera, et cetera. And so lawyers have always had this anxiety. They've always been thinking about law and development and law and, you know, whatever. But it's been much more pronounced, and it's taken the form among the more progressive or liberal cohorts around a nomenclature of political economy and law. In other words, it's an expression that certain people say in certain rooms, and we could start mapping out that ecology, not only in terms of the ideas or things that are said, though that would be very important, the conceptual architecture, the formal rhetorical economy of different professions in a world of struggle, as David Kennedy would call it, but also on the sort of background institutional rules, the organizational design, the cultures at certain places within the political economy of the political economy and law landscape, which itself is situated within distinct institutional places of intellectual and other bureaucratic production, right, and stuff like that. And so what I thought I would do is just talk to you today about a small piece of it. Like, I was in the airport one day and I saw these, you know, when you're walking through and they have the installation pictures or whatever. And I was walking through and there's these pictures of what had been somebody in a little, a Cessna airplane or whatever, taking pictures of the ground of crop circles. And it was so beautiful, like these layered patterns. And I went and found out who the person was, and he was like an 80-year-old like English professor who just had fallen in love with this. And it got me thinking, wow, there's so many different lineages and histories and the ways people talk and imagine the history and the disciplinary production. So I just want to look at one little piece of our society today, though obviously it would relate to others and we could talk in other worlds. I just want to talk about law academics, right? So within the, the mansion of different types of people who might claim to be law, among that distributed governance framework, just talk about law academics and try to shift it from not only speaking about the US, but start bringing in Europe, the UK, and some of the former colonial world, and those sort of like different outposts where we might have useful collaboration. And my feeling was what we could do is think about, sort of like share with you about how I'm understanding that space a little bit, and then think about how there's really a moment now for a happy coupling, an entanglement between MMT and lawyers and related experts related to global governance. And it's really needed, and I think the time's just about right. Okay, so that's a long rambling. My daughter would just look at me about halfway through and walk off, right? So thanks for being here with me. Okay, so that's what I thought I'd talk to you about. And I thought I would do it in two pieces. First, I would talk to you for 2 to 3 minutes, just as a general setup about the perspective in which I'm coming from to think about this. And maybe a little conceptual. And then I thought we could just jump into our landscape, right? Or something like that, and think through this together. Okay, great. So, so even though lawyers have started talking about this thing called law and political economy or political economy and law, they've made gestures towards understanding they need to have multidisciplinary collaboration, all those sort of things. That doesn't necessarily mean that the doxa, the underlying argumentative logic, the cultural repertoire, has actually changed all that much. In other words, the disciplinary sensibility may be going smooth and pretty much staying the same. It just has a slightly new vocabulary in which people are trying to leverage internally, right, to get more entrenched in their careers or to build out a movement, like as such. So oftentimes what you see among progressive lawyers is they'll go, okay, I'm going to do political economy and law. And what that means is I'm going to show you that the private is really public, right? So, or that the market is really according to background institutional rules. Fantastic, right? But like that's the magic. And they'll do a lot of that move, right? So it's just a blurring of the distinctions. Another one, they'll say, you know, what we've realized is law doesn't explain everything. So what we need to do is we need to pull from, you choose, anything in sociology, right? And that will be a translation project, which usually routinizes it back into the legal framework, right? Or says it's doing something new, but then when you look what it does new, it's sort of just filling in and doing more of the same thing, right? A good word on that is capitalism. So capitalism has come up as a word, but if you ask a Marxist international lawyer what capitalism is, they just sort of go, well, you kind of know what it is. You feel it in your gut, right? Maybe it's class and labor. And you go, well, there's always been kind of classes and like what make, and they go, well, it's actually resources or fixed investment. You know, they have all different answers. They rarely say it's capitalization. They rarely look to like accounting. They don't look at the differences between return on investment, return on equity. They don't think about, you know, value, like all the different strategies around risk mitigation and the history of the business schools. They don't think about the internal organizational dynamics of businesses. They talk more about the neoliberal Mont Pelerin economists. There's no professional studies in the law. So there's some real gaps right now, and there's still a lot of openness, and there's an understanding right now in the profession that we haven't quite got it right. There's a lot of dissent, there's a lot of struggle internally, both within the US, in the elite universities, and also globally with the community. So there's a real opportunity right now. They're very interested in understanding finance, markets, understanding that money is a legal instrument of democratic design, right? I think Christine Deson's really our hero among many people in the law for that sort of like realization and helping build that out with her organization, Just Money, based at Harvard Law School, and also with people like Raoul and Corinne at the Law and Political Economy Network that they're building out in student chapters across the US. I mean, there's a lot of stuff we'll talk about in just a second. So that's where the law's at right now, and there's a real need. And you know, what's very interesting is law usually says it turned to this because of the financial crash. But that's weird because historians, if you go read their literature, they were doing the turn to capitalism at least by 2004, 2005. Harvard has a whole program set up on the turn to the history of capitalism. They're teaching classes by 2005. Well, how does that jive? And the lawyers are sitting in on those sessions, right? So there's some complicated world that got us to this place. But right now what's been happening is that they're turning to this, trying to understand this money thing, and they usually neglect production, all of a sudden trade. You know, it's all about finance now. It's all about money design. Labor's dropped off the map, right? Or at least those people who do trade, labor, you know, all that other stuff, suddenly aren't part of those conversations. They're very distinct. So it's like, all of a sudden it's very cool and hip to be about international investment law as a public international lawyer making that move, but like workers drop out of that story, right? Or the production, you know, it's like that. And one of the great things about MMT that's on offer here is it fundamentally is about the job guarantee, in my understanding. That's, I mean, I think that's what's like spectacularly at the heart of something here. And it brings together that money side and that finance understanding, and it brings together that labor side for them to understand, to bring those back together, as scholars like Jeffrey Skolansky says and stuff like that. And specifically, international lawyers, for example, and that cohort that they hang with, political scientists, IPE scholars, you know, and such, those people really, that profession developed in relation to the developmental state. The rise of the bureaucratic thing that we call the state today, whether it's a nation state that justified that central administrative bureaucracy, if it justified itself on the basis of the nation, or nowadays on the market, right? That rise was really grounded, that's where the profession came out of. And it has a long history of working in that context as in service of the state, and ideally that should be in service of the people, right? The challenge has been in the global governance arena with lawyers and political scientists, the mainstream tradition is just completely taught in a different way and is ensured that the people who get into those positions and the arrangements and configurations of that stuff don't change. And so I just wanted to share with you a very slight lineage just to show you how stuck it is and how even like when the left does it, their answers aren't, money drops off the map. So if you think about lawyers, what they would say is like, this is canonical. So I'm just going to give you a lot of different like little quotes. The law of nations is just private law writ large. Holland, one of the founders of international law in the late 19th century. The story of the rise of nations is much like the story of money. It is a sum of legal ideas as a relation between individuals via contract law, right? The primordial law of all social organizations is contract law and transactions, right? You start getting this idea that international law and law comes out of barter just like money comes out of barter. In fact, they speak very specifically on, and these are the famous grandpapas and fathers of the profession. The PCIJ, the Permanent Court of International Justice, which was set up in the interwar period, and which had the mandate system that was doing the colonial stuff that we don't usually talk about, and which became the trusteeship system, which we don't usually talk about after, the UN in 1945, right? In that sort of system, here's what they say during that time. They go, look, in 1929, the PCIJ says, look, we understand as a general principle that a sovereign can regulate its own currency. So you would think, great, right? So why don't we drive money towards like social values we care about? But then what they do is they turn around and they say things like this, like Lastra, one of the most famous lawyers writing in this field, says, basically the fiat of the lawgiver cannot ultimately determine the value of money. And even if there was a public emergency or a financial meltdown, you have to ensure a productive business environment that includes the depoliticization of the management of money. They're very direct about it, right? So what they've done is they've hollowed out, they say the state's bad, totalitarian, we need to give it to the people, individual rights, normative individualism, whatever, but then what that really means is some version of the market, which really means allowing how capitalization and valuation and banking and the whole financial architecture to keep going on as is. And that undergirds, these are public international lawyers writing this in their side pieces and little articles. And what happened with the international law scene in the 1950s, they were very powerful. It was like these waspy dudes. It was a small group of them. The common law could probably fit inside this room, right? So they had very close access to power. That slipped away a lot over the last 50 years. You don't go to law to change the world anymore. You go to be influential in policy and make some money, right? But you're no longer part of that strata that it used to be, like the dulles, and everyone knew each other. And so as that slipped away, these academics who don't have as much clout as they used to within the legal have started realizing more and more the necessity of explaining why law does what law does. They can't just say it's because of law, right? And also explain what to do about it because they don't have the same clout to do it. They need to partner up, right? So that's where as I see where we are right now. Does that make sense, kind of? Okay, and that's the challenge we face, is against that still quite resonating sort of vibe that undergirds definitely the mainstream, but also sort of seeps into the more progressive thinking about it often. And that's where MMT really has something to tell us, as well as other, constitutional money and other theories. Okay, I'm sorry I talked so long at you. I know it's already a long day. Let me shift to my drawing. Is that okay? Sure. Cool, okay, so that took way too long, so I'm gonna try to do this up, but I'll be at lunch, would be happy to talk careers or like brainstorm about people or with, where you're at and people you wanna meet or, in this or something else. So basically what this is, I was drawing this a few days ago. I was trying to like sort of just visualize a little bit like what are the nooks and crannies of this political economy and law space, right? In terms of like people, right? Like, let's take seriously that the political is personal. It's all about interpersonal relationships and developing these trusted relationships with organizations and feeling it out. Okay, so how can we do this? I think what we've got here is let's start right over here. This is the US scene. In the United States, with lawyers, you basically have the Association for the Promotion of Political Economy and Law, APPEAL. That came out of something called class crits. That came out of the feminist movement of people like Martha McCluskey, came out of like the struggles over race and gender and intersectionality, right? So there's Angela and Martha, like we can share their scholarship with you, and they had built class crits, which was to tie law academics and feminist theorists and vulnerability theorist people with activists on the ground. And they built out something now that's been running for years and years, has like 500 people each event. And then they decided, well, we need something that's more like in a suit a little bit, and that will be on the side of teaming up with economists and folks to address this money thing and inequality from a finance side. So APPEAL got set up, very cool ecumenical group, very open to collaboration. And they work and then you have Just Money. That's Christine Desan. And she built out this wonderful network of scholars that are historians and people from the banking and like all sorts of folk. Relationships with the Institute for New Economic Thinking, people like Perry Mehrling and his Money View Symposium, all that kind of stuff. Rohan brings out, and they're based at Harvard. So you kind of got the Harvard thing, you've got this traveling APPEAL, you have class crits, which is more of the activism side. And over the last few years, the law and political economy movement, which sort of is related to Yale, but isn't officially institutionally embedded at Yale, and is part of a distributed network that puts on lots of events, produces material, and creates student chapters. That's the core of the law group, and then what you have are things like the Journal for Political Economy and Law, which is built by people within this space, which is now based at Berkeley for the next 5 years. You've got a lot of annual events that they go to, in particular the Law and Society. They've got like 150 people in an annual sort of like thread network group that they run through, and sort of related. That's sort of how the US thing, I mean, it could be complicated, but the US lawyers oftentimes are sort of talking in those sort of cohorts. Now, obviously, they relate in lots of ways to government agencies and different sort of like financial industries and such, but I'm just talking about the academic side of it for a second. Obviously, it'd be super important for us to identify for Progressive who are our clients, where's our revenue streams, and what sort of production, which is what I'd love to talk to you more about later. But we're just right now getting a snapshot from that aerial view of what's out there, so to speak, right? And we could talk about where funding comes from and that. In the international side, we've got some of this sort of stuff, which sort of goes from the US and abroad. So we have the IGLP, the Institute for Global Law and Policy, that was set up by David Kennedy, that comes out of the critical legal studies tradition at Harvard and sort of its more international side. And that's been running for about 10 years, 15 years. Wonderful group. And related to that is the Third World Approaches to International Law Network. They look at former colonial world, how international law was enmeshed in that. That's sort of the critical race studies on the global level that we could talk about. You've got and then you have people that they don't then you have the European Society of International Law, which has an annual conference, which has a talking series, which has a journal. Something very similar with the American Society of International Law, which has a side journal called Agile Unbound. And usually these cohorts that are among the progressives that are doing this, that are open to these things on the international level, they sort of find their way more into the Agile talk or front running or back running on the annual conference or talking on the Unbound part. And sometimes they get into the mainstream, but they're sort of always in that sort of space. Then we have sort of the people outside of international law traditionally, which have been increasingly brought in over the last few years, We have the European Association of Evolutionary Political Economists, which is a multidisciplinary crew in Europe of European scholars. They run a summer program in Rome, and they have an annual conference this year in Naples with a journal, the Journal of Institutional Economics. And there's also the EISA, which is basically they thought the political science movement in the US was a little conservative, a little too American, right? The International Sociology Association. So the EISA was set up for a more progressive sort of platform for European scholars to get together and think about international relations, international political economy, law and so forth, and really fun event. Okay, so within each of these sort of things, we could of course disaggregate it. So like IGLP has very strong relations in Geneva, at Toronto, in Paris with places like Sciences Po, in Melbourne, and primarily throughout the UK and London. I imagine there's probably at least 100 scholars with tenure track or tenure jobs at the law schools alone that are part of this network in collaborative. So there's a real concentration there. You could do the same with up there, for example, Erfurt, the VU in Amsterdam, the TMC Astor in The Hague, at Tilburg, et cetera. There's like another cluster of scholars that are doing the international relations and IPE thing. You know what I mean? At Copenhagen, there's a wonderful scholar that's bringing in the management side of it and so forth, right? Okay, so been thinking about how could these communities sort of explore non-intuitive, productive, healthy sort of collaboration together, and sort of like explore where there's institutional capacity to get along and do new things. And would be really interested with you to like unpack this more or talk about pieces of it or fill in the map, right? And think about it. And there's been a turn, you know, like there's a real openness now to the Global Institute of Sustainable Development, to Bard and Levy, to just the MMT crowd more open. I think we're in that place where we could start, you know, exploring what we do together. I'll wrap it up on this. Of course, I'm messing this up. It's Control and Alt-Tab. Let's try that again. There we go. So I've been thinking about it in terms of like a video game, right? Like actors and production styles. And so we've been like working over the last week in thinking about some of the things we can action. So for example, like onboarding PhDs, we've been thinking about where to get the funding for you, what sort of like events, how you could start building your publication track record, and we've got some ideas. I would love to talk more. I don't want to take the time right now, but I'll just put this on the screen for a moment and could come back to this in our talk this afternoon. There's a lot of ways we could think about building out capacity and thinking about what's worked in the past, and would love to talk to you more about that. Is that okay? I mean, I could talk differently, but I would be much more curious to like sort of have a conversation. Yeah, great. I think we have Chris with us, actually. Could we sort of turn to Chris? Thank you for the time together, gang. Yeah. Oh.
Are there any questions? Okay.
Awesome.
So John, I take it you're inviting me to give a few reactions to the presentations?
That would be super cool.
Okay, I'm not a formal member, but I'm totally fascinated and very excited by what Rohan and John have been talking about. Let me just, I don't want to take more time because I don't want to take much more time. I'll say a few things because it's so important to hear from the audience. For the very reason that John concluded with, which is, I think this is a really important moment for collaboration. I spend all of my time trying to think about how economists think, trying to re-articulate the relationship between money and finance and labor. Just to give you a genealogy, the reason that I, among others, have neglected that was in an effort to find space to get away from the knee-jerk tropes that attach, to be honest, especially in historical, but also in legal circles around Marxism and around labor, and that deflect and neglect the monetary and the importance of finance. Another thing that John said, the fifth thing that John said before I go back to the punchline, which strikes me as collaboration, is there are still dominant traditions in law, and in fact, financial regulation, the field known as FinReg, is absolutely dominant in the monetary and financial fields. So what John was quoting in the public international law comes out of and correlates, dovetails with American and European scholarship on financial regulation, which is quite conservative and assumes a market order that is quite like the neoclassical and before that classical views of the market. So all that ferment of diversity that John is pointing to nevertheless bumps up against the same citadel that you bump up against. It's just that we have some different possibilities, I think, than economists do. So to return to this collaboration point, and this also struck me about something Rohan said, and I'll just use it to make a point that I always make. This means that we take you very seriously. You should take law seriously. I do spend all of my time trying to decode what economists are thinking. Mostly trying to chip away at the orthodoxy, also trying to understand what you're thinking, how you're arguing, and at the same time, so I guess I don't spend all of my time, I am also, all of my work is an argument that law is not instrumental, not only instrumental, right? It is the terrain on which really important structures are being debated and built. It's the design, right, in which, and with which the dynamics that you focus on, I would say if we're going to split the field, it would be design versus dynamics or something like that. So to me, it is actually central to how the economy works is how those structures are operating. And so money it's not a question of what we can do with money. Money is a kind of governance project. So if you think about all those things I was talking about this morning, the way a claim works, who's paying for the claim, how to manage the claim, they go to the core of what the market is, right? What we think human agency is, what we think material value is, what we think public and private are for sure, what agencies, including what entities like banks we think should be creating credit, how they distribute credit. All of those decisions are legal, or as I think of it, constitutional small c, right, governance decisions, and therefore we can't actually, we can never be working separately, right? I can't ever think of those as economic decisions, and I'm sure you feel like the economic decisions can't hurt the legal ones, but they are always both, right? So I'm very much supportive of working with you to try to figure out kind of where we go from here. I'll stop there.
Any reaction?
Yeah, question? Yeah, Patricia? Sure.
I don't know if this is directly relevant to what you guys have been speaking about, but in many countries, my home country, in Peru, for example, we have the constitution has embedded within it a certain set of rules about how government should behave and manage money effectively. Basically embedded neoliberalism within the constitution, and once it's in the constitution, it sort of acquires this sacredness aspect to it, which is incredibly difficult to change. Very often I see constitutions being weaponized in this way against progressive change, and I wanted to know what your view was on constitutions at all, whether we needed them to have the rule of law, or whether you would go for something far more flexible.
I'll defer to Chris for the correct answer, but I'll give it a try of some answer. No, I mean, I think different countries' traditions lead them to a different conception of constitutionalism. I actually had an interesting discussion with a student last night about countries that have, ostensible monarchies, but maybe more Republican values than a country like America that's Republican but treats its president like a monarch. And so the extent to which a formal constitution, informal living, etc. I mean, I think there is historical contextual variation there. But I think to your broader point, because we often make the mistake of treating the law as instrumental, we think of making policy change means passing a bill. But then once you get to the Constitution, that's a little bit more tricky. So what are you doing? Are you picking up pitchforks? Are you going to try to maybe pull off that once-in-a-generation Chilean kind of coup move? And so that's a question that people who care about the Constitution and constitutional law are actually thinking about. And this is one of those examples that when it comes to legal change, there's more ways to skin a cat than just passing a bill or going to court. Right? We often think, oh, that's what lawyers do. They go to court or they go to the legislature and write the bill. But there are all sorts of ways in which you can foment legal change and activate legal power. And if we can't do it with constitutions, we have a bad theory of legal change and legal power building. So it isn't the end-all obstacle. It's just a different terrain to fight the same kinds of fights that require us to have different tools. And luckily, this is not the first time we've had to deal with an injustice that's been embedded in the Constitution. So we can look at the way that we've done that with other issues and bring that into the MMT story and make it something that isn't just, this is easy to do in parliamentary supremacy countries. This is easy to do without a living constitution. This is easy if we can find one small provision that we can bank this whole thing on and hopefully expand it outwards.
Yeah, thanks so much for that. I mean, I would almost turn it back to you, which I won't do right this second, and want to listen more about how you understand that scenario, right? And lean into thinking together and sort of feeling that out, right? Which would be really exciting. And then I think that's what law does. Like behind ideas of the state or lex specialis and a constitution, all super important sometimes, are background institutional rules, very messy relationships between public, private, multiple interest stakeholders, tons of informal relations. And where law comes in, I think, a lawyer's ultimately there to sort of like minimize your risk exposure, maximize your maneuverability, right? And to understand the institutional rule tactics, but also have those informal relationships where you know who to talk to, right? To understand the background arrangements of power. A lawyer's there really to broker relationships, curate collaboration, and sort of like participate in thinking through design, right? And then actioning it. But that's it, so we'd want to bring that and think about that. Rather than constitution, it's a different perspective of like, who do we know? What is this? You know what I mean? Like we want to think about those layers of distributed governance and power to me, and we'd have to start feeling that out together. Yeah, that's my sense maybe.
Chris, can you?
Chris, do you have?
Well, I had a couple of things. I mean, I think it's such a fascinating observation that neoliberalism is built into proving the Constitution. And my mind goes, not only do lawyers act in the modern day, but they also
Thank you. My question is directed to John Haskell. You've given us a portrait of the state of thinking in what I think could be characterized as the legal education profession. However, what struck me was how much of the terrain that you discuss is of the elites, the commanding heights of that profession. Harvard, Columbia, Yale, Sciences Po in France. And it really, I really have to wonder how big an impact this sort of thinking can have when it is mainly situated in these elite institutions. I don't begrudge the work that some of these people do. For example, I've read Christine's book, but I do know that at the elite level in universities, that's a culture unto themselves. And for those of us who are in non-elite universities or people who are hopefully going to be talking to like labor unions, religious congregations, and so forth, it just seems to me like you're in an entirely different world.
What was your name so I did?
James Keenan.
Dave? James. I'll be very brief. James, man, do I feel you. So I grew up in a very conservative, on the border of, a sort of Christian right-wing family. I was a very simple trunk of coal. I worked in a factory. I washed dishes growing up. You know what I mean? I can usually tell when someone hasn't worked jobs and has worked jobs, right? And I went to very sort of modest schools. I thought I'd be a therapist for lawyers. I thought they needed it, right? And then I sort of got wrapped. I realized I'd have to be around them all the time. That was the problem. Like, what was I thinking? This business model doesn't work. So I said, I'll go be an academic. And, I woke up to this former colonial world. The way that any conversation about America is even when you're doing union organizing and things in the States, that actually it's almost inherently racist. It's almost inherent, like the American experience is inherently tied to extraction. And lawyers are inherently part of that top 20% of the class, and we're not revolutionaries. In fact, very few people. And I don't know what to do with that, but at least maybe we need to have some clarity about that, right? So I like right off the bat, and I went to, some of my experience has been at more prestigious schools, but I also taught at the US at a very small law school that was actually owned by the Baptists, and that was an experience, right? So I share that with you, like that sort of like from that perspective of thinking, even if right now I'm not at that kind of university. And what I would say to that is that just two things. First of all, I don't know any movement where on the academic side that has not had a concentration of at least a few of the power places. Like, it seems to be one aspect of the game that you've got to be able to have in the pocket. It's not the only one. So if you look at like the American legal realist tradition or the critical legal studies tradition, each of these movements, they tend to have a concentration of academics at Harvard or Yale or Johns Hopkins or Columbia. You know what I mean? And that's actually been extremely important in even the build out of wrapping in all these other places. So for example, David Kennedy democratized the Harvard brand and has brought thousands of young emerging scholars and academics and policymakers from the global arena, right? There will be like 86 flags, right? Subsidizing the students to come. That only can happen because he's at Harvard, right? And that he has to be able to broker those relationships and create that platform. It'd be very hard to do at a small fourth tier school to be able to leverage that and get that aspect. So it's, there's that, right? And that's very much something that's on the table and thought about all the time, right? If politics is our sort of like our vocation, then responsibility has to be our fate. right? And thinking about that. The other thing I would say is that there actually beneath this is an enormous amount of collaboration. So even though it's at the Graduate Institute in Geneva, and even though it's at Sciences Po, it's also in Bogota, and it's in Finland, you know what I mean? And it's in all these places. It's at KwaZulu-Natal University in South Africa, right? There's tons of outposts, and trying to build capacity there and get those scholars at the IUC in Torino that just brings out subsidized students from Africa and tries to place them in Europe in positions. So there's all these things going on, and there needs to be a lot more of it. I would want to brainstorm with you about how we could distribute that. Like Raul and Corinne have been working to bring student chapters through all the law schools at any tier and get them together. So absolutely, yes, would love to talk more about that. Thank you for emphasizing that, and we'll take that back and would love to think more together with you about how to do more of that.
I want to make this answer too. This is a really important question, and I think there's a couple of things. First of all, Minsky loves to say anyone can create money, the challenge is to get it accepted. Well, anyone can create legal change, right? The challenge is to get that accepted too, which brings you immediately to the question of power, which obviously was where you should be thinking if you're a lawyer. And one of my old law professors used to say, I'm enough of a Marxist that I care how capitalists think. And I think in this situation, being enough of an anti-elitist that you care what elitists think and how they play the game is, I think, actually a really important part of the strategy, because if your assumption is that elite power is so disgusting that we can't even think about it, we can't even go there, then we are ascribing to a theory of powerlessness, actually, because there is power in that game. That doesn't mean we play it on their terms. It doesn't mean we play it unironically, but it does mean that there's power there. And, the anthropologist Laura Nader, Ralph Nader's sister, wrote a great article in the I think it was the 70s thing called Studying Up, and she said, so many anthropologists like to focus on downtrodden communities, on very marginalized communities, because that's who they empathize with, and they don't spend enough time anthropologizing the people up in the penthouse suite actually hurting those people, and that we actually need to spend some time thinking about how those people think and how they operate and what that power base looks like, and that means actually wanting enough of an influence in those spaces to move them where they can be and to challenge them where they can be. Paul Samuelson, in addition to his noble lie line, the other great line from him for me is, I don't care who writes a nation's laws as long as I get to write their textbooks. And he was talking about economic textbooks, but the reality is, and the other great line you hear sometimes in the law, is that the only thing that can overturn the Supreme Court is the law reviews. And what they mean there is that the wheels of legal academia grind slowly but exceedingly fine, and that even justices like Thomas and Scalia pushing this extreme right-wing vision of law have to be accountable to some theory of legal academic coherence, which is why before they could do what they did, they had to build bases at the elite law schools through student groups to set up journals to legitimize what they're doing as a legitimate Supreme Court doctrine. And part of that is because the elite law schools produce all the legal academics that go teach at all the other third, fourth tier law schools. I know that. I went to the elite law schools. I'm at a fourth tier law school now. And I wouldn't have got there without those credentials, and it wouldn't have been a reproductive process that allows me to go out to the periphery and empower them with the knowledge I learned if I didn't start by trying to get as much of that valor and stealing it and then redistributing it in different ways. And also, particularly in the United States, which is a rare little gift for us, the law reviews are primarily run by students. They're not peer-reviewed. There are some great peer-reviewed serious journals. Chris and others and Randy have published in many of them. But the fact that most of the big fancy pants Harvard Law Review, all that kind of stuff are run by students means even though universities historically embody the wisdom of the old, which is an inherently more reactionary force than the wisdom of the young, the law reviews are actually somewhat of a countervailing force of that. If I can convince 23-year-old idealists that I'm more interesting than those old reactionary bastards, then I can actually get that stuff published in that law review, and I can actually start to grind the wheels of those large doctrines exceedingly small. And so I think of it less as a theory of elite power, as a theory of class traitorship. The bourgeoisie often have a good insight into how to defeat the bourgeoisie for that exact reason. And it's important at that point, as John emphasized, solidarity. When I set up a public banking group at Oregon, I reached out to Chris, who's done it at the flagship law school in the country, and it made it much easier to validate what I was trying to do, that it already existed. And then I said to Chris, would you be willing to sit on my board? I know you do so many different things. She said, of course, because that's the solidarity that works here. And now I get to go to that fourth-tier school and say, you know what? It was Harvard Law School and then us. What does that say about what we're doing right now? And that's not because I validate Harvard Law School, it's because I'm validating Willamette and saying we can actually do something as good as that other thing equally effectively. So I think it's not that we want to have a theory of elite power, but we want to take elite power seriously. Chris?
I agree with what you both said. Nothing to add.
Rohan, can I add just a couple things? Just a few facts that I think illustrate the dynamics. Just a couple tidbits that illustrate the dynamics you're both discussing. Obviously, I agree that this...
He was going to be on this panel, thought he had to leave, is not leaving, now back in. I said to him at 9 a.m. this morning, good thing you're giving the keynote, and he looked at me like daggers. So now he's back.
All right, so I agree that this is about commandeering infrastructure. It is fundamentally a question of, are you serious about seizing the commanding heights or not? And we only have so many tools of power around. Some things don't work in the United States that might work elsewhere. And so what we're trying to do, and it's a slow process, but is to get people involved into these corridors of power in ways that they couldn't before. If you are a student group at Columbia, which is what we were, starting MMT stuff, that means we get to fly Randy, we get to fly Stephanie, all these people into Columbia Law School, where all the Wall Street lawyers are, where the people who run New York City are. And so we're opening the gates, essentially, right? Can we get everybody in there? Are there complications? Do we adopt a new frame? Because you can't, as you gain power, that changes how you view things. Those are all problems that are irreducible to some extent. However, it's getting people into these rooms, and through the law, we've brought in economists who have essentially been pushed out of those rooms, but we smuggle them back in. And then what's happening with the student groups is really important. This generational divide is very important. And you know, we're in this moment where people are deciding like woke or not woke, et cetera. But like the LP project, for example, is trying to like not ask the question that way. It is trying to bring people together and learn from all these different things, because of the sideload thinking in the law has been problematic. That necessarily involves communication between students at elite and non-elite law schools. The students at CUNY are the biggest student chapter. They started organizing and doing reading groups in combination with the organizing, with the people fighting Amazon, et cetera, in New York City. The literal model that they use is now what they're doing at Stanford. Like, that was an example of knowledge actually being imported from a school that is very different from these elite schools, and these connections being provided. So, well, it's not always apparent, and it sucks that like the LP project is at Yale, for example, in some ways. Like, there is fluidity going on here, and we are knocking down various gates. And the energy is ultimately going to come from the students, right, as to what happens next. And so you have to have a long view about this sort of stuff. And it's terrible, but like, you have to ask the question, like, how do we get the right people into the right rooms? Because they set this up as a high church system. It is not so easy to take power. I fundamentally believe that lawyers are not agents of social change, and like, movements will ultimately do that. Organizing ultimately does that. But like, somebody's got to get the keys and go into that room and like pull the lever. And so that's part of this process. Thank you all very much.
Sorry to take that.